An example of fraud in context of wills is usually forgery. A particular example that I've dealt with previously was a situation whereby someone had created an additional document known as a codicil, which is a document which adds to a will without the need to create a new will. And in this particular situation, the codicil was a fabrication. It was a forged signature, the witnesses were forged, and in those circumstances, that codicil was held to be invalid. As wills are something that do not necessarily involve legal supervision, they can be prepared at home, and that gives rise to the ability for people with less than honest intentions to try and falsify the documents. So for example, in the context of a will, you could create a will, forge the signature, but you would also then need to think about the witnesses, which you would either need to forge yourself or alternatively involve people who would then be party to that fraud. The evidence required in order to deal with a suspicion of fraud and forgery focuses on the creation of the will. Typically, those wills are not professionally drawn, so we wouldn't be looking to obtain copies of a will file or ask questions of the draftsperson. Rather, we'd be looking for evidence around the creation of the will, such as the computer files that might be available, the witnesses who are supposedly witnessed the signature, and obviously handwriting experts known as graphologists who can give expert opinion on whether or not the signature on the document in question is that of the testator.